All right. Welcome to another fun-filled legal analysis of a brand new lawsuit. This time it is Logan Paul being sued over his crypto zoo, crypto zoo, crypto project. I'll call it a crypto scam. I believe that's what it was. Uh, so A little personal background. I'm Joe. I'm an attorney licensed in the state of Utah. And background on this case. A couple of years ago, the massively successful YouTuber Logan Paul created a crypto project called Cryptozoo, and he never delivered on the promised results. So, couple months ago, I think right around Christmas, the YouTuber CoffeeZilla did a three-part expose on Cryptozoo and detailing the unkept promises, shall we say. So Logan Paul threatened to sue CoffeeZilla and then doubled down again, threatening to sue CoffeeZilla. Someone must have slapped some sense into him, and he apologized to CoffeeZilla. But then, a week or two later, the YouTuber and licensed Texas attorney Tom, made a video saying, "I'm suing Jake Paul or Logan Paul, not Jake Paul, Logan Paul." Kind of. And he went through the case, and the only problem is there's with CryptoZoo there was a arbitration clause and no class actions clause. So when he announced he was suing, he said, "In reality, I'm bringing a whole bunch of arbitration actions in Delaware, but there's a possibility we might have a actual case for a lawsuit." And that's this lawsuit. That's where we are today. So this is attorney Tom as the attorney, not as the plaintiff, in Texas for a class action suit. So I should specify this is only for Texas plaintiffs. Um, Attorney Tom actually did a video on, I think the either the 5th or 6th of February, detailing that it is only for Texas plaintiffs. Because the law on those the terms and conditions for CryptoZoo varies state by state. So if you are a CryptoZoo victim, check your state laws, talk to an attorney in your state, talk to attorney Tom. He might be willing to represent you in uh, arbitration, or point you in the direction of someone willing to represent you in arbitration. Uh, if you are a Texas p- prospective plaintiff or a class member, contact attorney Tom. You could be a member of the class. So, with that, let's dive into the lawsuit. So, what we have here is the complaint, which is the document that starts the lawsuit. And it's in the United States District Court for the Western District of Texas, Austin Division. Don Holland, plaintiff, individually and on behalf of all others similarly situated. That would be the class. Versus Cryptozoo Inc., a Delaware corporation. Logan Paul, Danielle Strobel, Jeffrey Levin, Eduardo Ibanez, Jake Greenbaum, aka Crypto King, and Ofer Bentov, aka Ben Roth. Jury trial demanded. Comes now. I always giggle. Comes now. Plaintiff Don Holland, on behalf of himself and all other similarly situated individuals, and alleges on personal knowledge, investigation of his counsel, and on belief, information and belief, the following claims against defendants: Cryptozoo Inc., Logan Paul, Danielle Strobel, Jeffrey Levin, Eddie Ibanez, Jake Greenbaum, aka Crypto King, and Ofer Bentov, aka Ben Roth, collectively defendants. Nature of action. Plaintiff Don Holland is a police officer residing in Round Rock, Texas, who purchased digital currency products from defendants. Cryptozoo Inc. is a Delaware corporation that created and or sells digital currency products in the form of a digital currency called Zoo tokens, which could be purchased which could be used to purchase defendants' other products. Cryptozoo non-fungible tokens, CZ NFTs, for use in its online game Cryptozoo. Non-fungible tokens, NFTs, as discussed below, are a form of digital assets that can be purchased, sold, and transferred on the Binance blockchain. Logan Paul is an entertainer with a sizable online audience. Based on his own statements, information, and belief, he is a founder and majority owner of Cryptozoo Inc. Danielle Strobel is Logan Paul's assistant and one of the founders of Cryptozoo Inc. Jeffrey Levin is Logan Paul's manager and one of the founders of Cryptozoo. Eduardo Ibanez is the lead developer of Cryptozoo and one of the founders of Cryptozoo. Jake Greenbaum, aka Crypto King, is one of the founders of Cryptozoo. And Ofer Bentov, aka Ben Roth, is the manager of the Cryptozoo community. Def- Defendants promoted Cryptozoo Inc.'s products using Mr. Paul's online platforms to consumers unfamiliar with digital currency products, leading to tens of thousands of people purchasing said products. Unbeknownst to customers, the game did not work or never existed, and defendants manipulated the digital currency market for Zoo tokens to their advantage. The defendants executed a rug pull, which is a colloquial term used to describe a scheme in which an NFT developer solicits funds from prospective NFT purchasers, promising them certain benefits. Once the purchasers' funds are used to purchase the NFTs, the developers abruptly abandon the project and fail to deliver the promised benefits, all while fraudulently retaining the purchaser's funds. As part of the defendant's NFT scheme, defendants marketed CZ NFTs to purchasers by falsely claiming that, in exchange for transferring cryptocurrency to purchase the CZ NFT, purchasers would later receive benefits, including, among other things, rewards, exclusive access to other cryptocurrency assets, and the support of an online ecosystem to use and market CZ NFTs. In reality, soon after completing the sale of all their CZ NFTs, defendants, together with others, transferred millions of dollars worth of purchasers' cryptocurrency to, among other places, wallets controlled by defendants. Acknowledging Cryptozoo's failings on January 13th, 2023, that's the apology video where he supposedly owns up to his failings and apologizes to CoffeeZilla. Mr. Paul released a video promising to 1. Burn his and Mr. Levin's zoo tokens, 2. Create a rewards program for disappointed base egg and base animals holders, and 3. To finish and deliver the game. The rewards program involves burning your base egg or base animal for the mint price, zero point 0.1 ETH equivalent in BNB. What? I'm not sure what BNB is. Only 2 or 3 sets of CZ NFTs in Cryptozoo. So, okay, so the rewards program involves burning your base egg or base animal for the mint price. Only two of three sets of CZ NFTs in Cryptozoo. That sentence has me a little lost. The program does not include defendants' profitable zoo tokens used to participate in the failed crypto zoo or the third set of CZ NFTs, hybrid animals. Around the same time, Mr. Paul, or someone acting on his behalf, posted messages to the crypto zoo community confirming the exclusion of consumers who had already sold CZ NFTs from the rewards program. Um, and this is Joao Rui Amorim asked, "What will happen to people who sold everything at a loss?" Uh, that entire quote isn't there, but Logan Paul said, yeah, Logan Paul says just the current owners. Uh, King Vincent Six says, "If you sell, you lose," and Logan Paul liked that or hearted it or something. So Paul also posted that no one in the CryptoZoo community should put any more money into CryptoZoo, framing it as an investment before saying CryptoZoo was not intended as an investment vehicle. So Logan Paul posts, "Please do not put any more money into CryptoZoo." Marvin says, "When you say don't put money anymore in CryptoZoo, what are you trying to say?" Hunter K responds to that. He's probably saying, "Hey, I'm sick of you guys blaming your investment decisions on me, so I'm putting it in writing, don't buy anymore." But that's just my guess, which Logan Paul responds to with two carrot or whatever, two up arrows. And then he responds to Marvin, "Hey Marvin, I believe there's been a misconception here. As outlined in the white paper, Zoo was created to support CryptoZoo and was not intended to be an investment vehicle. Eggs were zero point 0.1 ETH. When you sold or bought was not my decision." And quoting the liquidity section of the white paper, "Because Zoo was created to support CryptoZoo and was not intended to be an investment vehicle, the contract doesn't include incentives for liquidity providing, although the largest in the." So when you bought or sold was not my decision. Yet they bought and sold on the reliance that you'd finish the project. So, and that you'd finish it on time. That's kind of a big deal. Mr. Paul stated he would no longer be the scapegoat for anyone's financial decisions in denying responsibility for plaintiff and the CryptoZoo community's losses. That's pretty straightforward. Uh, This action seeks redress from defendants for their fraudulently promoting and selling products that did not function as advertised, failing to support the CryptoZoo project, and manipulating the digital currency. Defendants operated this fraudulent venture to exploit and steal from plaintiff and other customers who trusted Mr. Paul's false representations. As a result, defendants defrauded plaintiff and thousands of other consumers and unjustly enriched themselves by profiting off plaintiff and others without delivering on their promises. Plaintiff is one of numerous consumers who purchased Zoo tokens from defendants and who was damaged by defendants' manipulation of the Zoo token market. Plaintiff seeks past and future compensation for defendants' fraudulent actions and other damages available under his causes of action. Subject matter and jurisdiction. This court has original jurisdiction of this action under 28 USC 1332. This controversy is between citizens of different states, and the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and costs. So they're claiming this under, or they're bringing this lawsuit under diversity jurisdiction. The requirements: all defendants have to be in have to be domiciled in different states from all plaintiffs, and the amount in controversy has to exceed $75,000. So, venue in this court is proper under 28 USC 1391B. The venue is where you bring the lawsuit. The claims asserted in the action arose in this district. A substantial part of the activities, conduct, and or damages giving rise to the claims occurred in this district, and defendants have substantial contacts with this district. So basically, they're saying, hey, the defendants bought in this district. So therefore, the substantial contacts, the substantial actions arose in this district. Parties and personal jurisdiction. Okay, I'm going to read the states. This includes their personal address. Don't be jackasses. Don't do anything with it. Cryptozoo is a Delaware corporation located in Middletown, Delaware. Logan Paul is a United States citizen who may be located in Puerto Rico. Danielle Strobel is a United States citizen who resides in Boulder, Colorado. Jeffrey Levin is a United States citizen who resides in Palisades, California. Eduardo Ibanez is a United States citizen who resides in Westport, Connecticut. Jake Greenbaum, aka Crypto King, is a United States citizen who resides in Alpharetta, Georgia. And Ofer Bentov, aka Ben Roth, is a United States citizen who resides in Woodland Hills, California. So notice no Texas residents in the defendants, but all plaintiffs, all members of the class, the named plaintiff, are all Texas residents. So that should satisfy the requirements, at least, for diversity jurisdiction, what it takes to get it into federal court. Background on digital assets, cryptocurrency, and NFTs. A cryptocurrency is a digital or virtual currency circulated over the internet as a form of value. Cryptocurrencies are created and their transaction records are verified and maintained by a decentralized system using cryptography rather than through a centralized authority like a bank or government. Like traditional fiat currency, there are multiple types of cryptocurrencies, e.g., Bitcoin, Ether, and Binance token, BNB. Ah, okay. That's the BNB that had me confused up above. For full disclosure, I absolutely hate crypto. I think it's all a scam. At least cryptocurrencies hold no actual value. Um, it would have been nice. Clearly, he wrote this section first, and then the above section where he mentioned BNB. Otherwise, he should have done this first. Um, Due to its centralized nature and limited regulation, cryptocurrency users can transfer funds over the blockchain more anonymously compared to traditional banking and credit systems, thus, it being a favorite of drug dealers and money launderers. Um, so, to some, this may seem like overly basic background. It's not. This is being heard by a federal judge who is probably in their 50s or 60s and may have heard of Bitcoin, but not known exactly what it is. Cryptocurrency owners typically store their cryptocurrency in digital wallets, which are identified by unique electronic addresses. Wallets allow cryptocurrency users to store and retrieve their digital assets and can hold multiple cryptocurrencies. Each digital wallet has a unique cryptographic address, which is used to facilitate transfers of cryptocurrency between wallet addresses. These types of cryptocurrency transactions are completed using one, a public key, which is akin to a bank account number or public facing email address, and two, a corresponding private key, which is akin to a bank 4-digit PIN or email password that allows a user the ability to access and transfer value or information stored at the public address. Users may transfer cryptocurrency to the public address represented as a case sensitive string of letters and numbers, 26 to 36 characters long. Each public address is controlled and or accessed using a unique corresponding private key. Only the holder of an address's private key can authorize transfers of cryptocurrency from that address to another cryptocurrency address. A user may control multiple public blockchain addresses simultaneously. So, I wonder, the president on the movie Spaceballs, if he had a 26 character long password, would it just be the alphabet A to Z? These are the things that keep me awake at night. And if it were 36 characters long, would it be A to Z and then 1 to 10? Well, 0 to 9. Each cryptocurrency transaction, regardless of the cryptocurrency denomination, is recorded on a blockchain, which acts as a public accounting ledger. Unlike a traditional bank's ledger, the transactions reflected in a blockchain are distributed across numerous participants that, together, form a network. For each cryptocurrency transaction occurring on a blockchain, the blockchain public ledger records, among other things, the following transaction details: the date and time, the unique cryptocurrency addresses involved in the transaction, including the addresses of sending and receiving parties, and the amount of cryptocurrency transferred. The blockchain does not identify the parties who control the cryptocurrency addresses involved in each transaction. However, because each cryptocurrency address is unique, anyone can review other transactions recorded on the blockchain related to the transfer and trace the flow of cryptocurrency. Tracing cryptocurrency to a particular user can be complicated. However, by a user's reliance on multiple cryptocurrency addresses to transfer funds or the use of mixers, which in practice can be used to obscure the link between the sender and receiver of transferred cryptocurrency by commingling cryptocurrencies from multiple transferring parties into a pool before sending specific amounts onto an intended recipient. That sounds like the digital equivalent of money laundering. And so that this tracking of funds from wallet to wallet is basically CoffeeZilla's bread and butter. So he did an awful lot of that in this investigation, but he's done it in a lot of other investigations as well. An NFT is a unique digital item that is recorded on a blockchain and cannot be copied, substituted, or subdivided. In other words, each NFT is a one of a kind digital item. NFTs can also be transferred on the blockchain. Many NFTs exist as part of the Ethereum blockchain, Like cryptocurrencies, NFTs are uniquely identifiable on the blockchain. Once minted, an NFT can no longer be edited, modified, or deleted. NFTs can be created in multiple forms, but one of the most common types of NFTs is an image data file similar to a JPEG image file. However, unlike a JPEG image file, the NFT provides the owner with an electronic image and corresponding certificate of ownership. NFTs can also act as a utility token, allowing an NFT owner to access reward programs, giveaways, and access to other digital assets by virtue of their NFT ownership. NFTs are created through a process referred to as minting and relies on the use of a smart contract. A smart contract is a piece of computer code that runs on a blockchain. In simple terms, a smart contract is a program that automatically executes defined tasks when and if certain conditions are met. A smart contract system often follows if then statements. For example, a smart contract might be coded to release electronic currency to a party automatically upon the occurrence of an agreed upon event without the need for further action by either party to the contract. The minting of NFTs relies on smart contracts to govern the creation, sale, and any subsequent transfers of the NFTs after minting. NFT smart contract code is publicly viewable on the blockchain. Misnomer slash alter ego. In the event any parties are misnamed or are not included here, it is plaintiff's contention that such was a misidentification or misnomer, and or such parties are slash were alter egos of parties named here. Alternatively, plaintiff contends that such corporate veils should be pierced to hold such parties properly included in the interest of justice. So the corporate veil is basically, well, something I haven't done yet, but I intend to. I'm going to make probably an LLC as the corporate owner of my YouTube channel. And if I do everything right, and I'm going to make a video of this in the near future. If I do everything right, as far as separating myself from the LLC, I can't be sued personally for any torts or breaches of contract or whatever committed by my LLC. You can sue the LLC, you can't sue me. But if I don't do everything right, you can pierce the corporate veil, the nebulous legal protections, the legal separation, and say, you know what, we're suing Joe too, and that's called piercing the corporate veil. So that's why you really need to be careful um, in setting up corporations or even, partnerships, but that has its own set of oof. Generally, just stay away from partnerships. Principal agent liability. Now, for those of you who are here specifically for Logan Paul, this is just another segment. But for those of you who have been following the Delete Laws saga, I'm going to mention this in that video as well. But this is how you allege a principal agent liability. All allegations here of acts or omissions by defendants include, but are not limited to, acts and omissions of such defendants, officers, directors, operators, managers, supervisors, employees, affiliates, subsidiaries, vice principals, partners, agents, servants, and owners. Plaintiff alleges that such acts and omissions were committed or made with express and or implied authority of the defendants or were ratified or otherwise approved by the same defendants, or otherwise that such acts or omissions were made in the routine normal course of the actor's employment or agency and within the scope of the agency or employment as the case may be. Factual allegations as to plaintiff. Plaintiff began investing in cryptocurrency in 2016. In 2021, Plaintiff was told by his son about a new NFT project with Logan Paul. Cryptozoo was promoted by Mr. Paul as a game that makes you money, with a massive team supporting it, funded by like $1 million Mr. Paul claimed to have invested. In August of 2021, defendants released the Zoo tokens, CZ NFTs, and CryptoZoo's terms stating defendants will strive to do the best for the project and the community. See Exhibit 1. I'm not going to scroll down to Exhibit 1 yet. Although, no, this is Exhibit 1, I believe. This is a CryptoZoo egg and the terms and conditions. And this is provided through the Wayback Machine. Shortly thereafter, plaintiff invested an initial $1,000 to purchase Zoo tokens, which he used to purchase an CZ NFT. After the launch date came and went, the investment initially went down in price before going up and then back down, which is when a lot of individuals fear began to fear the project due to lack of positive developments. Like others, plaintiff thought there was long-term merit in the project due to the false affirmations by the development team, including from Ben Roth. It was a steady drip of information on positive developments, which were untrue, that led him to believe the project was legitimate. Accordingly, plaintiff spent an additional approximately $2,000 after his initial investment for a total of $3,000. Now, I have thoughts here. They are not kind for the plaintiff here. Whatever you think of crypto, like I said, I don't like crypto, but thinking, well, this project has merit. Logan Paul's attached. Did he forget about the dink doink rug pull? Remember, Logan Paul has had other scams in the past, namely dink doink. He has, I believe, promoted, if not as the owner, but he's advertised for payment multiple other crypto scams. It, I mean, fool me once, but that doesn't mean though that the plaintiff isn't entitled to recover. He was dumb, I think, in believing Logan Paul, but that doesn't mean he's not entitled to recover. Once he saw Logan Paul announce another NFT project and started ignoring Zoo, he realized his money was likely lost. Cryptozoo was never released as advertised, and the value of the Zoo tokens and CZ NFTs plummeted. The value continued to drop because defendants manipulated the market for Zoo tokens by buying and selling them in bulk. Defendants caused plaintiff to effectively lose the vast majority of the value of the assets, around $3,000, he used to purchase the Zoo tokens. Defendant's scheme caused damages to plaintiff and other consumers. Defendants knew consumers like plaintiff would be convinced to purchase their products by defendants' false representations of profit and a functional game. On information and belief, defendants made the business decision to forego an expensive and time consuming process to create a functional Cryptozoo game or support it, and instead deliberately undertook a scheme to defraud plaintiff and other consumers. On information and belief, June 11th, 2021 was considered internally by defendants as Zoo Day, the day upon which they released, without any public notice, their digital products for purchase on the Binance blockchain. On Zoo Day, and until the release was publicly announced, Logan Paul, Danielle Strobel, Jeffrey Levin, Eddie Ibanez, Jake and Jake Greenbaum, aka Crypto King, purchased these digital products at an artificially low value. Soon after the project was publicly announced, Eddie Ibanez, Jake Greenbaum, and potentially other defendants sold large amounts of the digital products for an immediate and large profit, effectively stealing the money of consumers who had invested. Defendants knew they were supposed to hold on to any early purchased digital products until months after the public release because they knew that selling before then constitutes a rug pull and is fraudulent. Due to the unconscionability of defendants' fraudulent scheme, defendants should disgorge the revenue, profit, and any other gains made therefrom to plaintiff. On information and belief, defendants manipulated the Zoo token market. Their standard operating procedure has been to promise products they failed to deliver on, on only to abandon the project and community they promised to support. Due to these unconscionable practices, defendants should disgorge any revenue, profits, or any other gains from their scheme to plaintiff. Logan Paul and defendants knew or should have known that they were falsely advertising a non functional product and that consumers would be deceived by their false representation. Defendants acted with reckless disregard when they made such false representations and are responsible for plaintiff's damages. Section 8, Class Action Allegations. So here they discuss why this should be granted class action status. So class actions are governed by Rule 23 of the Federal Rules of Civil Procedure. And 23A is the prerequisites. One or more members of a class may sue or be sued as representative parties on behalf of all members, only if 1. The class is so numerous that joinder of all members is impractical. 2. There are no questions of law or fact, or there are common questions of law or fact common to the class. So that would be the actions taken by Logan Paul and his co-defendants are basically exactly the same concerning any prospective plaintiff. The claims or defenses of the representative parties are typical of the claims or defenses of the class, and the representative parties will fairly and adequately protect the interests of the class. So that means basically the named plaintiff in this action, the class representative, he gets to decide if Logan Paul and his co-defendants make a settlement offer. He gets to decide on behalf of the whole class whether or not to accept. So, for starters, he's got to accept a fair deal for the whole class. And he can't say, "Well, give me everything I need as a condition and then, a lesser amount for the class." Well, that's not fairly representing and protecting the interests. So, And then there's section B is types of class actions, section C is certification, D is conducting the action, E settlement, voluntary dismissal, or compromise. F is appeals, G class counsel, that's attorney Tom, H attorney's fees. So some of those will be discussed in the complaint. The main thing to keep into under consideration, though, is A, the prerequisites, and there's 4 of them. Plaintiff brings this action under Rule 23B2 and 3 of the Federal Rules of Civil Procedure on behalf of a class tentatively defined as. So remember, 23B was the types of class actions. So 2 and 3. 2, the party opposing the class has acted or refused to act on grounds that apply generally to the class so that final injunctive relief and corresponding declaratory relief is appropriate respecting the class as a whole. Or 3, the, the court finds that the questions of law or fact common to class members predominate over any questions affecting only individual members and that a class action is superior to other available methods for fairly and efficiently adjudicating the controversy. The matters pertinent to these findings include uh, A, the class member's interests in individually controlling the prosecution or defense of separate actions. B, the extent and nature of any litigation concerning the controversy already begun by or against class members. C, the desirability or undesirability of concentrating the litigation of the claims in the particular forum. And D, the likely difficulties in managing a class action. So, the class is tentatively defined as Cryptozoo class, all persons who purchased zoo tokens and or Cryptozoo NFTs while in Texas prior to the filing of this action. Simple. All Texans, all residents of Texas who purchased zoo tokens or Cryptozoo NFTs. Those are the proposed members of the class. Excluded from the class definition are any employees, officers, directors of defendants, and attorneys appearing in this case, and any judge assigned to hear this action. So if the judge is a purchaser of Cryptozoo, they're not a member of the class. They can bring their own litigation in front of a different judge, or they can bring the arbitration in Delaware. They can do it in through other means. They just can't be a member of the class and then decide the lawsuit on behalf of the class. Imagine that. Although, if they are a victim of Cryptozoo, presumably they'd recuse themselves in about a second, kick it off to another judge, and then say, hey, I'm a part of this class. Plaintiff reserves the right to modify this class definition as he obtains relevant information. So it's possible, it's unlikely, but it's possible as attorney Tom does more research, he might decide, you know what? It makes sense to add more states that uh, that would allow litigation as opposed to strictly adhering to the arbitration clause. Let's let's add them to the class. Or maybe it's decided the arbitration clause is wholly unconscionable across the board. Have one class, period. That's unlikely, but you never know. The proposed class can be identified through defendant's records and Binance blockchain records containing, amongst other information, the relevant digital currency transactions. Such data indicates there is approximately 20,000 victims, and on information and belief, there are thousands in Texas. Accordingly, the number of putative Cryptozoo class members is believed to be in the thousands, rendering the class so numerous that individual joinder of all class members is impracticable. Plaintiff is a member of the proposed class. Commonality. Remember, commonality is one of the requirements for a class action. There are questions of fact common to the putative Cryptozoo class, and those questions predominate over questions affecting any individual putative Cryptozoo class member. Common questions of fact include, but are not limited to, A. Whether defendants fraudulently promoted products or services that did not exist as promoted, causing consumers like those in the putative Cryptozoo class to purchase said products or services. B. Whether defendants violated their agreement to deliver a functional product and breached their agreement. C. Whether defendants knew Cryptozoo would not be functional when they claimed it would be and made false representations despite that knowledge. D. Whether defendants had a duty to provide a functional product to their consumers and if defendants violated that duty. E. Whether defendants failed to deliver on its promises to consumers to provide a functional product. F. Whether defendant made any false representations to their consumers and whether defendants knew those representations to be false and and whether those assertions were made recklessly and without adequate investigation of their truth or falsity. G. Whether defendants received revenues from their fraudulent venture and the amount of those revenues. H. Whether defendant manipulated the market for zoo tokens and their NFTs. And I. Whether defendants had a duty to not manipulate the market for zoo and whether defendants violated that duty. There are questions of law common to the putative Cryptozoo class, and those questions predominate over questions affecting any individual putative Cryptozoo class member. Common questions of law include, but are not limited to, A. Whether defendants' conduct in 1. Making false representations about Cryptozoo, 2. Failing to provide a functional Cryptozoo product, and 3. Manipulating the zoo token market constitute acts of fraud. B. Whether defendants' conduct common to the putative Cryptozoo class has resulted or will result in defendant being enriched at the expense of putative Cryptozoo class members, or in defendant retaining a benefit to the detriment and loss of class members. I'm not going to keep saying putative Cryptozoo class members. In frustration of the fundamental principles of justice, equity, and good conscience, and thus constitutes unjust enrichment. And C. Whether defendant's conduct common to the class demonstrates willfulness, malice, or recklessness, and whether defendant proceeded with conscious disregard for the rights of others, therefore entitling class members to punitive damages. Typicality, prong 2 of the requirements. Typically, Civil Procedure Rule 23A3, plaintiffs Plaintiff's claims are typical of the claims of the class members. Plaintiff would only seek individual or actual damages if class certification is denied. If it's denied, then he wouldn't have federal jurisdiction because his damages of around 3,000 don't meet the jurisdictional amount of 75,000, but then he could bring the case in state court, in Texas state court, or bring an individual arbitration. In addition, Plaintiff is entitled to relief under the same causes of action and upon the same facts as the other members of the class. Adequacy. Federal Rule of Civil Procedure 23A4. Plaintiff is an adequate representative of the proposed putative cryptozoo class because his interests coincide with and are not antagonistic to the members of the Cryptozoo class he seeks to represent. He has retained counsel competent and experienced in such litigation, and he intends to prosecute this action vigorously. Plaintiff and his counsel will fairly and adequately protect the interests of the members of the class. Superiority. Civil Procedure 23B3. So that's the four prongs. Questions of law and fact common to the class members predominate over questions affecting only individual members, and a class action is superior to other available methods for fair and efficient adjudication of the controversy. Liability will be determined based on a common set of facts and legal theories. Willfulness will be determined based on defendant's conduct and knowledge, not upon the effect of defendant's conduct on class members. The damages sought by each member are such that individual prosecution would be burdensome and expensive given the complex and extensive litigation necessitated by defendant's conduct. It would be virtually impossible for members of the class individually to redress effectively the wrongs done to them, even if the members of the class themselves could afford such individual litigation. It would be an unnecessary burden on the courts. Furthermore, individualized litigation presents a potential for inconsistent or contradictory judgments and increases the delay and expense to all parties and to the court system presented by the complex legal and factual issues raised by defendants' conduct. By contrast, the class action device will result in substantial benefits to the litigants and the court by allowing the court to resolve numerous individual claims based upon a single set of proof in one case. Causes of action. Count one, fraud. So, here at the start of each cause of action, I'm going to go to the essential elements of each cause of action. I want you to think, once I've read that, and and then come back to the complaint. I want you to think of what those elements are and think, are they met? So the elements for fraud in Texas. This is on the freemanlaw.com website. Fraud is generally a common law tort. So it's hard to go to the Texas revised statutes to find fraud. So it's just easier to go to the lawyer's website and look. I'm using Freeman Law quite extensively, but it's laid out nicely. So, the elements of a fraud claim. In order to establish a fraud claim under Texas law, a plaintiff must demonstrate the following elements: that the defendant made a material material representation. Material. Immaterial representations. If Logan Paul said his shoelaces were green in the white paper, but his shoelaces were white, that's a misrepresentation, but it's not a material misrepresentation. So it wouldn't go towards a fraud claim. 2, the representation was false. 3, the defendant knew the representation was false or made it recklessly without any knowledge of its truth. 4, the defendant intended to induce the plaintiff to act upon the representation And 5, the plaintiff justifiably relied on the representation, which caused the plaintiff injury. Close that to unclutter. Oops. So, count 1, fraud. Plaintiff incorporates by reference the foregoing paragraphs as if of this demand as if fully set forth here. Defendants failed to disclose that Cryptozoo was non-functional as promoted and that they would not be supporting the project. Defendants have no practice of providing promised product products/projects and supporting said projects/products. This is a signal attribute of fraud because defendants represented to provide the promoted products/projects and to do what was best for the plaintiff and other consumers. Moreover, in related context and as previously alleged, defendants had a duty to provide the promoted products/projects and to do what was best for the plaintiffs, investors, and other consumers, but chose to proceed in violation of this duty. Rather than make candid, straightforward disclosure of their material failures, defendants ignored them. Plaintiff and other consumers were ignorant of these material failures and did not stand an equal opportunity with defendants to know they existed. They had no way of knowing what sort of products/projects would be implemented or what contractual terms defendants injected to immunize their scheme. In this context, these purported contractual terms have the additional effect of intentionally misleading plaintiff and other consumers concerning defendants' practices. These customers cannot reasonably expect that defendants would take their assets and fail to provide a functional crypto zoo, fail to support the community, or manipulate the zoo token market. But this is reflected repeatedly in plaintiff statements as presented in this demand. There's a lot of tongue twisters in there. Count 2, express breach of contract. So, breach of contract, Texas law requires the following elements to establish a breach of contract. A valid contract exists. The plaintiff performed or tendered performance as contractually required. The defendant breached the contract by failing to perform or tender performance as required, and the plaintiff sustained damages due to the breach. Um, and then, under Texas law, a breach of contract occurs when a party to a contract fails to perform an act that it has expressly or impliedly promised to perform. So, in this case, express breach of contract means these are the express terms of the contract. This is what is written in the contract. This is what is discussed in the contract. If those terms are not met, it's an express breach of contract. Implied breach of contract would be the breach of an implied term of the contract. And for that, trying to think of an example of what an implied term would be, but it would be, I promise to make this many computers for you by such and such date, and of these specifications. But then, no, it's late. I'm, and it doesn't matter anyway because they're not suing for implied breach of contract. They're suing for express breach of contract. Let's go back to the complaint. Plaintiff incorporates by reference the foregoing paragraphs as if fully set forth herein. Plaintiff alleges that he entered into a valid and enforceable express contracts or was a third party beneficiary of valid and enforceable express contracts with defendants. The valid and enforceable express contracts that plaintiff entered with defendants include defendants' representations that they would provide a functional version of Cryptozoo at the time the zoo tokens and CZ NFTs were publicly noticed and or released as for sale. The express contracts also include violations of defendants' then current terms of service. Under these express contracts, defendants and or their affiliated contractors or associates promised and were obligated to A, provide a functional version of CryptoZoo upon which the value of Zoo tokens and CZ NFTs were at least partially dependent, and B, provide the agreed terms in exchange for plaintiffs and other investments in defendants' products/services. In exchange, plaintiff and other consumers agreed to pay money for these products/services. Both the A provision of the functioning crypto zoo and the B obligation that defendants will strive to do the best for the community and project and the community of the participants in cryptozoo, amongst other obligations, were material aspects of these agreements. At all relevant times, defendants expressly represented in their promotions that Cryptozoo would be functional by September 1st, 2021, and they will strive to do the best for the project and the community of participants in Cryptozoo. Defendants had a duty to provide a functional Cryptozoo product, especially if they were taking assets from plaintiff and other consumers in exchange for access to it. Instead, plaintiffs pocketed plaintiffs and other consumers' money and mostly forgot, according to the publicly available information about the failed endeavor until receiving negative media attention. CoffeeZilla. Defendants express representations, including, but not limited to, express representations found in their advertising and promotion, formed an express verbal contract/offer requiring defendants to provide a functional cryptozoo and to strive to do the best for the project and the community of participants in cryptozoo. Plaintiff trusted defendants' representations and proposed agreements related to their products. Yet, defendants failed to provide the promoted product and do what was best for their consumers, even lying about the underlying investment in the project. The CryptoZoo tokens and CZ NFTs are essentially worthless, in part because CryptoZoo was never released. Plaintiff would not have entered into these agreements with defendant without believing CryptoZoo would function and be supported by defendants. A meeting of the minds occurred as plaintiff and other consumers invested in defendants' digital projects in exchange for, amongst other things, a functioning cryptozoo and defendants' support of it. Plaintiff performed his obligations under the contract when he paid for defendants' digital products. Defendants materially breached their contractual obligations to provide a functional cryptozoo and support the project. Defendants materially breached the terms of these express contracts, including, but not limited to, the terms stated in their promotions and then current terms of service. The ensuing damages were a reasonably foreseeable consequence of defendants' actions in breach of these contracts. As a result of defendants' failure to fulfill the obligations promised in these contracts, plaintiff and other consumers did not receive the full benefit of the bargain and instead received products that were of a diminished value to that described in the agreements. Defendants therefore damaged plaintiff in an amount at least equal to the difference in the value of the zoo tokens he paid for and the value he was left with, which is essentially nothing. The value he's left with, that is. Had defendants disclosed that CryptoZoo was non functional or that they were not going to support the project, neither the plaintiff nor any reasonable person would have purchased slash invested in defendant's products slash services. As a direct and proximate result of these breaches, plaintiff has been harmed and has suffered and will continue to suffer actual damages and injuries, including, without limitation, the loss of assets and loss of use of those assets, out of pocket expenses, and the loss of the benefit of the bargain he had struck with defendants. Plaintiff is entitled to compensatory and consequential damages suffered as a result of these breaches. C. Implied breach of contract. Oh, apparently there is implied breach of contract. Well, let's see what the implied terms are here, since I'm not thinking of a good hypothetical. Plaintiff incorporates by reference the foregoing paragraphs of this demand as if fully set forth here. When plaintiff and other consumers provided their investment slash monies to defendants in exchange for defendants' services and products required to participate in Cryptozoo, they entered into implied contracts with defendants under which defendants agreed to reasonably provide a functional Cryptozoo and support it. That sounds like an express promise to me, an express to, you know, make the project that they promised to make, but let's continue. Defendants solicited and invited plaintiff and other consumers to invest slash pay for its digital products as part of defendant's regular business practices. Plaintiff accepted defendant's offers and provided assets to defendants. In entering into such implied contracts, plaintiff reasonably believed and expected that defendants would provide a functional Cryptozoo and support the project. Plaintiff provided assets to defendants reasonably believing and expecting that defendants would provide a functional Cryptozoo and support the project. Plaintiff would not have provided his assets to defendants in the absence of the implied contract between him and defendants to provide a functional Cryptozoo and support the project. Plaintiff would not have entrusted his assets to defendants in the absence of their implied promise to provide a functional Cryptozoo and support the project. Plaintiff fully and adequately performed his obligations under the implied contracts with defendants. Defendants breached their implied contracts with plaintiff by failing to provide a functional Cryptozoo and support the project. As a direct and proximate result of defendants' breaches of these implied contracts, plaintiff sustained damages as alleged here. Plaintiff is entitled to compensatory and consequential damages suffered as a result of these breaches. So, what I think Attorney Tom is doing here, because, like I said, that sounds to me like an actual promise, not an implied promise, um, or contract, I should say. So, and it pretty much looked like the same contractual promises as above, the express promises. So, what what I think he's doing here without expressly saying he's doing it, I think he's pleading in the alternative. Now, regular watchers will hopefully by now know what pleading in the alternative is. But pleading in the alternative is saying, I think it's this, but on the chance that it's not that, I also think it's that. So it's, I think he stole my car. But if he didn't steal my car, I think he's still responsible because he paid someone to steal my car. Those are two separate things, but You can lay out the evidence and let the jury decide which one to believe. So if they say, "Well, that's not an express contract, but it is an implied contract." So Attorney Tom's saying here, I think, well, I think it's an express contract, but if it's not, it's got to at least be an implied contract. So count 4, unjust enrichment. Once again, we're returning to freemanlaw.com. So, to be successful in an unjust enrichment claim, the plaintiff must prove the following three elements. One, a party is unjustly enriched. Two, the receipt of the benefit by one party came at another party's detriment. Three, there is no contract between the parties, either due to unenforceability, impossibility, mistake, voidness, or absence of formal agreement. So, some jurisdictions or some scholars call this unjust enrichment. Some call it a quasi contract. Some call it quantum meruit. Um, so, it's basically breach of contract, except there was no contract, but you got the benefit of it. So, like, the hypothetical that my contracts professor used is, let's say there's a roofer and he is hired by my neighbor to put a new roof on their house, but he mistakes the address and puts a new roof on my house. And he finishes, and then he bills me and says, "Pay me for your new roof." I say, "Hey, we don't have a contract." He says, "Well, if you don't pay, you've been unjustly enriched. You've got a brand new roof that I put on. I provided the shingles. You've got to pay me for it." And which, you know, do I have to pay him? Well, it kind of depends. You know, if I put on a brand new roof just last year, well, he damaged my brand new roof and then replaced it. I'm in no better position than I was before. So, at best, I have a one instead of 29 years left on a 30-year roof. I have 30 years left on a new roof. So, do I pay you 1/30th, or do I sue you for damaging my brand new roof? But if I had a terrible roof and needed a new one anyway, then I've got a brand new roof now that I haven't paid for. Do I have to? Maybe. But then let's say I have a terrible roof and I see the roofer up there right as he's getting started, and my neighbor even sees him, and he calls me. I don't know why he in this hypothetical, he wouldn't go to the roofer and say, "Hey, moron, it's this house over here." But, y you know, I'm put on notice in multiple ways that the roofer is mistakenly doing my roof. And I think to myself, "I need a new roof. I'll let him finish." And then he finishes and I say, "You did the wrong house, moron. I'm not paying you." Well, then did I have a duty to mitigate the damages, to stop him from going through all that effort and maybe just repairing the couple shingles he'd torn off? So basically, that's what unjust enrichment is, and the analysis that you go through for unjust enrichment. So let's see if there's unjust enrichment in what they plead here. Plaintiff incorporates the foregoing paragraphs as if fully set forth herein. as direct and proximate result of defendant's intentional and unlawful taking of plaintiff's assets without providing the promised product slash services, plaintiff has been deprived of the profits of and other benefits of purchasing slash investing in defendant's products. Defendants have been unjustly enriched by its wrongful receipt and retention of profits and other benefits it deprived plaintiff, and in equity, defendants should not be allowed to retain their revenues and benefits. Plaintiff is entitled to a judgment requiring defendants to disgorge all sums they have received as revenue and other benefits arising from its unconscionable and unlawful failure to provide a functional cryptozoo, failure to provide the or to support the project, and manipulation of the zoo token market. So I actually think, once again, that this is pleading in the alternative without saying pleading in the alternative. I don't actually think like it's breach of contract. It's fraud, but it is it unjust enrichment? I mean, possibly if the jury says, you know what, it there was no contract. Was there at least a quasi contract? The unjust enrichment. So that's why it's pled. That's why it's pled. Count 5, violation of Texas's Deceptive Trade Practices Act. So let's return to Freeman's Law. And under the Deceptive Trade Practices Act, plaintiffs must establish three elements. The plaintiff is a consumer, a defendant engaged in false, misleading, or deceptive acts, and the acts were producing or the acts were a producing cause of the consumer's damages. Plaintiff incorporates the foregoing paragraphs. Blah blah. Plaintiff is a consumer under the DTPA. Hey, that's the first requirement. Defendant's conduct concerning their false advertising, failure to provide the promised product services, manipulation of the zoo market token market, failure to disclose information concerning the progress of Cryptozoo, and failure to support plaintiff and the Cryptozoo community as enumerated in this demand constitute false, unfair, misleading, unconscionable, and or deceptive acts under the DTPA. These facts were known to defendants at all times and done with the intent to induce plaintiff and consumers to provide assets to defendants, remain in the program after it initially failed, or engage in transactions that they would not otherwise have engaged had the information withheld been known to them. Defendants' conduct concerning their misrepresentations and failures as enumerated in this demand was unfair, misleading, and unconscionable under the DTPA. Defendants should not be allowed to rely on their terms of service to escape liability for their accused practices and profit from their own wrong. As a direct and proximate result of defendants' intentional, unconscionable, misleading, unfair, and unlawful conduct, plaintiff has been deprived of the profits and other benefits of purchasing investing in defendants' products slash services. Plaintiff has been damaged by defendants' willful violation of the DTPA and is entitled to relief in the form of treble damages, attorney's fees, and costs. So, this is a big one. This is a big one. Treble damages, triple damages. So many times, statutes, which the Deceptive Trade Practices Act is, have provisions for treble damages because the government thinks this is so heinous. We've got, you know, if the defendant lost $3,000 or the plaintiff lost $3,000, he's entitled to $9,000 instead, plus attorney's fees and costs. This is the one that Logan Paul and others do not want. to make it to trial. This is going to be ludicrously expensive. Count 6, negligence. So, this is basic negligence. The it's really the first thing you learn in torts law in law school. There's a duty, breach of duty, cause in fact, proximate cause, and damages. So, duty. The defendant should have acted or not acted in a certain way owing to a duty to act or not act. So, like the example in this, motorists have a duty to pay attention to the road and not be distracted by cell phones or other stimuli. Breach of duty. Defendant failed to do something or refrain from doing something that is considered his or her duty. For example, a motorist who was reading text messages and hit a pedestrian has breached his or her duty to pay attention to the road. Cause in fact, the injury was in fact, and injury here could be economic injury, not just physical injury, was in fact caused by the defendant's breach of duty. So, in that example, the pedestrian would not have been struck and injured had the motorist who hit him been paying attention. And then the proximate cause, was it obvious to a reasonable person that texting while driving could result in someone's injury? So the negligence has to be sufficiently related to the injuries or damages sustained. So here, what happens if there, there was a tire blowout simultaneous to reading the text messages, and it was a brand new tire, just complete act of God. So was it the proximate cause of the injury, the reading text messages? And then damages, actual harm to the plaintiff. So, count 6, negligence. Plaintiff incorporates by reference the foregoing paragraphs. By representing to the public that Cryptozoo would be functional, was seeded with around $1 million, and that the Cryptozoo community would be supported, defendants had a duty of care to use reasonable means to provide the promised products/services, not manipulate the zoo token market, and support plaintiff and the other members of the Cryptozoo community arose from the special relationship that existed between plaintiff and defendants. Defendants were positioned to ensure that the promised products/services would be delivered, and that the zoo token market was not manipulated, and to support plaintiff and the other members of the Crypto Zoo community. Defendants breached their duties and thus were negligent by failing to provide the promised products/services, not manipulating the zoo token market, and failing to support plaintiff and the other members of the Crypto Zoo community. The specific negligent acts and omissions committed by defendants include, but are not limited to, A. Promoting products or services that did not exist as promoted, causing plaintiff to purchase said products or services under false pretenses. B. Representing that Cryptozoo would be functional and making false representations despite that knowledge. C. Willfully failing to provide functional products and services to their consumer even after receiving revenues from their fraudulent venture. D. Willfully manipulating the market for zoo tokens and CZ NFTs. And E. Willfully failing to support plaintiff and the Cryptozoo community. It was foreseeable that defendants' failures to provide the promised products/services, not manipulate the zoo token market, and support plaintiff and the other members of the Crypto Zoo community would result in one or more types of injuries to plaintiff. Plaintiff is entitled to compensatory and consequential damages suffered as a result of defendant's negligent failures. Count 7, fraudulent misrepresentation. I believe we have a PDF here. So, the elements of fraudulent misrepresentation. Five elements. 1. The defendant made a false representation of a past or existing material fact susceptible of knowledge. 2. The defendant did so knowing the representation was false and without knowing whether it was true or false. 3. The defendant intended to induce the plaintiff to act in reliance of that representation. 4. The plaintiff acted in reliance on defendant's false representation. And 5. Plaintiff suffered pecuniary damage as a result of that reliance. And that comes from the case Valspar Refinish Inc. versus Gaylords Inc. Plaintiff incorporates by reference the foregoing paragraphs. Blah, blah, blah. Defendants fraudulently represented to the public that Cryptozoo would be functional and that they would be supporting the project and the Cryptozoo community. Upon information and belief, defendants knew that Cryptozoo would never be functional and that they had no intention of supporting the project or the Cryptozoo community, including plaintiff. Defendants had a duty to tell its consumers, including plaintiff, that Cryptozoo would never be functional and that they had no intention of supporting the project or the Cryptozoo community. Rather than make candid, straightforward disclosures to their consumers, including plaintiff, defendants willfully concealed that Cryptozoo would never be functional and that they had no intention of supporting the project or the Cryptozoo community. Plaintiff would not have purchased defendant's products but for the reliance on defendant's material statements that Cryptozoo would be functional and that they would be supporting the project and the Cryptozoo community. As a result, plaintiff is entitled to the compensatory and consequential damages suffered as a result of defendant's fraudulent representation. Count 8, conspiracy to commit fraud. So, we discussed the elements of fraud up above. Here, as a separate count, we have conspiracy to commit fraud. And the elements of a civil conspiracy are 5 elements once again. 1, a combination of 2 or more persons. The persons seek to Number 2, the persons seek to accomplish an object of or course of action. 3, the persons reach a meeting of the minds on the object or course of action. 4, one or more unlawful, overt acts are taken in pursuance of the object or course of action. And 5, damages occur as a proximate result. And that's citing First United Pentecostal Church of Beaumont versus Parker, which is a Texas court case from 2017. Oops. So, count 8, conspiracy to commit fraud. Plaintiff incorporates by reference, blah, blah, blah. Defendants conspired with one another and potentially others, as yet unknown, to commit the acts set forth in this demand. Said conspiracy constitutes a conspiracy to defraud plaintiff and other consumers. Plaintiff, unaware of the falsity of statements made by defendants and in reliance on their accuracy, paid money to defendants based on such fraudulent statements. Plaintiff has been damaged as a result of defendant's conspiracy to commit fraud. Damages. Plaintiff hereby adopts by reference each and every foregoing paragraph of the stated in this demand as if fully and completely set forth here. Defendant's conduct and actions discussed above proximately caused injury to plaintiff, which resulted in 1. Loss of use damages for assets diminished by defendant's actions. 2. Actual damages and treble damages under the Deceptive Trade Practices Act. Exemplary damages under the Deceptive Trade Practices Act and common law fraud. Actual damages, including economic damages under all causes of action. 5. As a direct and proximate result of defendant's breaches of contracts, plaintiff sustained damages as alleged here. 6. Plaintiff is entitled to compensatory and consequential damages suffered as a result of defendant's fraud and actions. 7. Mental anguish. 8. Civil penalties. 9. Prejudgment interest. 10. Attorney's fees. And 11. Costs of action. Plaintiff further seeks unliquidated damages within the jurisdictional limits of this court. Punitive damages. Those are those ones punitives aren't meant to compensate plaintiffs. They're meant to punish the defendants. Plaintiff incorporates blah blah blah. The wrong done to plaintiff by defendants was attended by fraudulent, malicious, intentional, willful, wanton, or reckless conduct that evidenced a conscious disregard for plaintiff's rights. Therefore, plaintiff seeks punitive damages in an amount to be proven at trial. Attorney's fees. Once again, everything's re-alleged. Plaintiff is entitled to recover reasonable attorney fees and request the attorney's fees be awarded under his breach of contract claims. Incorporation of paragraphs. Every paragraph in this demand is hereby incorporated into every other paragraph. Prayer for relief. Wherefore, plaintiff prays for judgment against defendants, awarding relief as follows. A. For equitable relief, requiring restitution and disgorgement of the revenues wrongfully retained as result of defendant's wrongful conduct. That sounds like legal relief to me, but what do I know? B. Holding that the doctrine of unjust enrichment applies and ordering defendants to pay plaintiff all sums received by defendants flowing from their illegal and unconscionable activities. C. For an award of actual damages, compensatory damages, statutory damages, exemplary damages, and statutory penalties in an amount to be determined as allowable by law. D. For an award of punitive damages as allowable by law. E. For an award of attorney's fees and costs and any other expenses, including expert witness fees. Expert witnesses are expensive. Pre and post judgment interest in any amounts awarded, and such other further relief as this court may deem just and proper. Respectfully submitted, Jarrett L. Elzy, Elzy and Associates PLC, and Attorney Tom and Associates, Tom Kirker, Prohoc Vichy. That's the complaint. So, what do you guys think? Having seen both the elements of every cause of action and the allegations contained in the complaint, what do you think? Do you think some causes of action are valid? All causes of action? None of them? Do you think Logan Paul wins outright? Um, Let me know. I think I think Logan Paul is going to take a big financial hit here. Um, Very big financial hit. It's and especially that treble damages from the Deceptive Trade Practices Act that could really hurt. And ooh, so like I said, I think a few of the causes of action are basically pled in the alternative without saying it. Um, I think the big question mark is still the terms of service. Are they allowed to sue? Are they allowed to bring a class action? Do they have to go to arbitration? Other than that, it's pretty obvious that this was a rug pull. So I I think if it gets past certification, it's a fairly straightforward win. It's still going to take a lot of time and a lot of effort, a lot of work, but the facts are there. So with that, you know, if you haven't, go watch the CoffeeZilla 3-part expose. Go watch Attorney Tom doing discussing the arbitration, and then now discussing a little bit about how he brought the class action. Uh, like and subscribe to those guys, and please like, share, and subscribe here. With that, thank you for joining me. I will hopefully see you all again very soon because I plan on covering this case as it goes along. So, with that, have a good one. Bye bye.